Good morning, everyone. What would a Zoom webinar be without some technical difficulties to start out? We were going to have Tiffany Stokes, our president, the president of Leaf Edmonton, welcome everyone to the breakfast, but she has lost her internet access and access to Zoom. So I am the MC for today. My name is Lise Gotel. I'm the Landrex Distinguished Professor in the Department of Women's and Gender Studies at the University of Alberta. So welcome, everyone. Just a few housekeeping matters before we start. The pandemic has cut off our face-to-face access with one another, and we know that the Person's Day breakfast is a time when people like to network. So I just wanted to let you know that the chat function will be open throughout today's program, and you can use the chat program as a way to connect with one another, but please note that your name will appear associated with any comment that you make on the chat, so it's not private. But we invite you to use the chat as a way of networking, saying hello to old friends. If you're experiencing any difficulty with the video or audio of the webinar, please let us know on the chat and we will try to solve the issue. I wanted to also let you know how the question and answer is going to work for this morning. At the end of our keynote this morning, there'll be time for questions and comments. Please use the question and answer tab at the bottom of the Zoom window as a way of posting questions or comments for Dr. Napoleon. These can be anonymous and they will be grouped together and posed by one of our Leaf Edmonton volunteers to the speaker. All right, so now that we've got now that we have the housekeeping matters cleared up for this morning, I wanted to begin by acknowledging that we are virtually gathered this morning on Treaty 6 territory, the ancestral lands and traditional gathering place of diverse Indigenous people, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community. So happy Person's Day, everyone. What a strange year it is. I would really love to be looking out at a ballroom where I could see all of your faces in person. And again, I know that you're missing the opportunity to see your friends and colleagues. We're all here this morning because we share a commitment to carry forward the Equality Rights Project that began with Edwards versus Canada. It's so sad that we can't use this as an opportunity to connect with one another, but again, I invite you to use the chat as a means to do this virtually. Not only is this the 91st anniversary of the Person's case, it's also Leaf's 35th anniversary in 2020. As you may know, Leaf was established on the day that the equality rights provision of the Charter came into effect in 1985. Leaf was founded to advance the substantive equality rights of women and girls through law reform and litigation. One of Leaf's founding mothers, Helena Freeland, was from Edmonton. We're delighted that Senator Mary Lou McPhedran, another of Leaf's founding mothers, is able to be with us virtually today from Ottawa. As you may know, Leaf's members are its branches, and Leaf Edmonton is Leaf's most engaged and active branch. We have a long history of feminist legal activism in Edmonton. Let me take a moment to emphasize the critical necessity of Leaf's ongoing advocacy work. Earlier this summer, the Royal Bank of Canada released a study showing that the pandemic had set women's economic equality back by 3 decades. Here in Alberta, we're facing a very challenging context of austerity, and one that is going to disproportionately and is disproportionately affecting Alberta women. and in particular, Indigenous women, women with disabilities, and elderly women. At a time when women require economic support and investment in childcare, we are instead being told that thousands of women nurses, healthcare workers, education workers, and civil servants will face layoffs. And just 2 weeks ago, on the eve of Persons Day, we learned that an Alberta scholarship, the Persons Case Scholarship, established in 1979 to honor the legacy of the Persons Case, was being eliminated. And that scholarship recognized students, post-secondary students whose work advanced gender equality. So we need organizations like LEAF to continue to fight for gender equality now more than ever. And we can't do this without your support. So thank you for purchasing your ticket to this event. You can also take a minute during the program this morning or after it's over to go to LEAF's website, leaf.ca, and sign up to be a member and to be a donor, be a monthly donor. That way you can ensure that this important struggle for women's substantive equality will continue. Excuse me. It's been a very busy year for LEAF Edmonton. We played a leading role in the successful fight against Bill 207. And Bill 207, you might remember, was a private member's bill that would have allowed any healthcare provider in this province to refuse service or even referral based on conscientious beliefs. This bill would have threatened women's access to reproductive health care and trans people's access to gender-affirming surgery. LEAF Edmonton members collaborated with LEAF National in preparing a submission setting out how Bill 207 would have contravened Section 15 of the Charter. We also participated in a virtual conversation on safer public spaces for women and girls in Edmonton that was organized by City of Edmonton Councillor Bev Eslinger. LEAF Edmonton was particularly concerned about the steps that are being taken by Edmonton Transit to improve safety for women and girls. LEAF Edmonton is very grateful to have received a generous donation from the McQuaig Desrochers Centennial Fund. This donation will help LEAF Edmonton support LEAF Edmonton's Only Yes Means Yes program, which is a sexual consent education program delivered to high school students and junior high school students. When we started to plan this year's event, we weren't sure whether we'd be able to meet in person. In the early days of the pandemic, I don't think any of us understood the profound and ongoing disruption that COVID would cause. I'm delighted to announce that despite the fact that the Persons Day breakfast is by necessity virtual this year, we have the largest audience we've ever had. Nearly 360 people have bought tickets this morning. And unlike other years when most of our attendees came from Edmonton, this year we have supporters from across Alberta, from across Canada, from coast to coast, almost every province. We even have at least one supporter joining us this morning from Europe. We're also joined by a number of VIPs, and I sincerely apologize if I miss anyone. This morning we have with us Greg Mady, who is the president of the Edmonton and District Labour Council. Mike Parker, who is the president of the Health Sciences Association of Alberta, and Trudy Thompson, who is vice president. Secretary Treasurer Siobhan Vipon from the Alberta Federation of Labour is also here, along with Elizabeth Johansson, the president of the Non-Academic Staff Association at the University of Alberta. Heather Smith, president of the United Nurses of Alberta, is also here, along with second vice president Cameron Westhead. And Karen Kennedy, president of the Alberta Federation of Union Retirees, is with us as well. We also have a number of Indigenous women leaders this morning. Rochelle Venn, CEO of the Institute for the Advancement of Alberta Aboriginal Women, excuse me. Brenda Parks, Governance Coordinator from the Wolastoqey Tribal Council. Catherine Gull, Bail Coordinator from Nishnawbe Aski Legal Services. Karen Erickson, the Director of Family Services from Native Counseling Services of Alberta. We are delighted that other Alberta women's advocacy groups are here with us this morning. Jan Reimer, Executive Director of the Alberta Council of Women's Shelters, is here, along with Catherine O'Neill, CEO of YWCA Edmonton, and Mary Jane James, the CEO of the Sexual Assault Center of Edmonton. We have a number of LEAF National Board members and staff members with us virtually today from across the country. And Gillian Natu, Chair of the LEAF National Board, is with us, along with Mary Lou McPhedran, who is the Chair of the LEAF Foundation. Finally, we have a number of legislators and elected representatives in attendance, including Senator Mary Lou McPhedran, Senator Kim Pate. We also have a number of opposition MLAs here this morning, including Janice Irwin, Status of Women critic, along with Marie Renaud, Shannon Phillips, Christina Gray. And we have Andrew Knack, Councillor Ward 1 Edmonton City Council. Finally, we have a huge number of attendees from Edmonton post-secondaries, including Barbara Billingsley, who is the Dean of Law at the University of Alberta, and Jennifer Ma, who is the Dean of Health and Community Studies at Norquest College. Now let me turn to Megan Stevens. Megan is the Executive Director and General Counsel at LEAF National, and she will be delivering the LEAF National update.
Good morning, everyone. And thank you so much, Lise, for that introduction. Before I begin my remarks today, I also want to begin by acknowledging the sacred land on which I am working and in which LEAF National's offices are located. I am based in the Dish with One Spoon territory, otherwise known as Toronto. The Dish with One Spoon is a treaty between the Anishinaabe, the Mississaugas, and the Haudenosaunee, and that treaty bound them to share the territory and protect the land. The Dish with One Spoon continues to have important significance. We all eat out of the dish, all of us that share this territory, with only one spoon, meaning we must all share the responsibility to ensure that the dish is never empty, including taking care of the land and creatures that we share it with. There are no knives at this table, and thus we must keep the peace. The work that LEAF does to advance gender equality is only possible if we acknowledge and reckon with our colonial history. This land acknowledgement recognizes our responsibility to work towards decolonization, to acknowledge and address the harms perpetuated by colonialism and racism, and to seek to be true allies in all aspects of our work. It seems to me after the events of the past weekend out in Nova Scotia, it's really important to think about what these land acknowledgements mean and about our colonial history, which continues to create inequality across this country. So I am here obviously to give you an update on the work at the national office this year. But before I do, I really also want to take a moment to thank LEAF Edmonton for inviting me to be here today and for really all of the incredibly hard work that has gone into pulling off this first ever virtual breakfast. As I said when we all met up earlier to prepare for this, there are some silver linings to the current pandemic that we are living through. And I think one of it is the ability to allow people to come together to attend these events, even if it is virtually, who would not otherwise have been able to do so. I saw in the chat someone had said they had gone to the University of Alberta in law school, but been out in New Brunswick since 2008. So fantastic to see things like that and to see the attendance the attendance at this event. I also really want to thank Leaf Edmonton for the incredible work they do throughout the year. Lee's summed up at least part of it nicely. And Leaf, as Lee's pointed out, really does remain our most engaged and active branch, bringing together so many in the community out in Edmonton who are passionate about advancing gender equality, but really supporting us at Leaf National as well and flagging important issues for us to be aware of. I also want to thank all of this year's attendees, all of you who are here from across the country, for joining in for this important talk by Dr. Napoleon, and for your ongoing support of LEAF. Your support always means so much to us, but in this current year with so much fiscal uncertainty, it's really essential. Without you, we simply wouldn't be able to continue our work fighting for gender equality in Canada. So it would really take quite a long time to cover all the work that Leaf National has been involved in over the past year. So I really want to just highlight 3 important interventions that we've been involved with, and also briefly touch on a couple of the law reform matters and major projects we're working on. So the first case I want to highlight for you is a case called the Queen and Sharma. This was a judgment that came out of the Ontario Court of Appeal this past summer, and it was a sentence appeal that was brought by Cheyenne Sharma, a young Indigenous woman who is an intergenerational residential school survivor and a single mother. She had acted as a drug courier and was convicted of importing drugs. That happened because she was facing financial hardship and possible eviction for her and her 2-year-old daughter. As an Indigenous person, Ms. Sharma should have been entitled to what is known as the Gladue framework, which requires judges sentencing Indigenous offenders to consider alternatives to incarceration, such as a conditional sentence of imprisonment that's more commonly understood as house arrest. However, an amendment to the Criminal Code in 2012 had eliminated the possibility of conditional sentences for offenses that would include importing drugs. It essentially eliminated them for offenses with a maximum sentence of 14 years or life. So this made it impossible for a sentencing judge to apply the Gladue framework in cases like Ms. Sharma's. At her trial, Ms. Sharma challenged the constitutionality of that 2012 amendment, arguing that the provisions infringed her Section 15 equality rights. But the sentencing judge rejected this argument and imposed a sentence of imprisonment. Ms. Sharma appealed her decision to the Court of Appeal, and in November 2019, LEAF and the David Asper Centre for Constitutional Rights appeared before the Court of Appeal for Ontario to intervene in this case. We argued that the constitutionality of the provisions really needed to be assessed in the context of systemic discrimination against Indigenous people, especially Indigenous women, in the administration of criminal justice. That discrimination is really evident in the overwhelming over-incarceration of Indigenous women in Canada. And despite criminal code amendments and decisions like Gladue, the problem has actually been increasing in recent years. So in March 2018, just to give you an idea of exactly the extent of the overrepresentation of Indigenous women in our prison system, in March 2018, Indigenous women made up about 4% of the total Canadian population, but they actually made up 40% of all federally incarcerated women. So it's a huge problem and one we all should be concerned about. In July 2020, I'm happy to report that the majority of the Court of Appeal struck down those criminal code provisions that made conditional sentences unavailable for Ms. Sharma, finding that her equality rights had been infringed. Unfortunately, Ms. Sharma will not benefit directly from this decision because, as is too often the case in sentence appeals, she had actually completed her sentence before the appeal was heard. But this judgment is nevertheless a really important one, which will help ensure that future Indigenous offenders receive the benefit of the Gladue framework and a consideration of alternative to imprisonment when they are being sentenced. The majority's analysis in this case is really a watershed of sorts in terms of its recognition both of a Section 15 violation in a case of adverse impact discrimination. These are the most challenging to make out, and also because it recognized that in the criminal law context, this has not happened, and so it's really an important case. The Crown has applied for leave to appeal to the Supreme Court of Canada. We were a bit disappointed to hear that, but perhaps not entirely surprised. LEAF will be following this case closely, and we will be working to ensure that the gains for the substantive equality rights of Indigenous women are not rolled back. And I see Senator Kim Pate, who has been a real advocate on these issues for years, decades really, has put in the chat that in fact Indigenous women now make up 44% of federally sentenced prisoners. So again, just since 2018, the problem is compounding itself. So the second case that I want to talk to you about is one I'm actually delighted to speak about. And this is the decision that just came out on Friday from the Supreme Court of Canada in a case called Fraser and the Attorney General of Canada. This case involved the unequal treatment of female RCMP officers in relation to the RCMP's pension plan. Ms. Fraser, who's actually from Leduc, Alberta, so near, very close to Edmonton, and two other former female RCMP officers had participated in a job sharing program so that they could continue to work while also managing their child care responsibilities. The RCMP pension plan, however, did not allow them to buy back pension credits for the time they spent in that job sharing program, unlike those who took a leave without pay. The three women ultimately filed a claim in federal court arguing that the pension consequences of job sharing had a discriminatory impact on women, contrary to Section 15 of the Charter. Their challenge failed at both the trial level and at the Federal Court of Appeal for many of the reasons we too often see being used to diffuse claims of adverse effects discrimination. So LEAF intervened in this appeal to the Supreme Court of Canada to argue that the substantive equality analysis required by Section 15 had to give full consideration to the context of the claim, including the systemic devaluation of women's work and caregiving responsibilities. The majority decision allowing the appeal, I think it's worth noting, was written by Justice Abella Long, a champion of equality rights in this country, who is in her final year on the Supreme Court. The judgment is a resounding affirmation of substantive equality as the animating norm of Section 15 of the Charter. The decision is really a significant one for both women's equality and in terms of its powerful recognition of the impact of the double burden for women as employees and caregivers. The court also provides a much needed roadmap for future cases involving systemic discrimination. Justice Abella's clarification both about what is needed to establish adverse impact discrimination as well as what is not is particularly welcome. As many LEAF supporters will know, there have been significant barriers to such claims in the past. I think it's worth noting that it's actually been over 2 decades since a Section 15 adverse effects discrimination claim has been successful at the Supreme Court of Canada. But we all know too well that systemic discrimination remains an insidious problem in this country over 35 years after Section 15 came into effect. Justice Abella really issues a clarion call to critically examine existing structures and policies which may appear neutral, but as she says, can set powerful limits or act as built-in headwinds for those who do not share the characteristics of the people originally intended to benefit from them. So if you have not read this decision, I really encourage you to take the time to do so. It's important not just because it will serve as a cogent guide for all future systemic discrimination cases. It also really reads like a celebration of LEAF's 35 years of advocacy. Justice Abella draws extensively on intersectional feminist scholarship to emphasize how an individual's position in society can result in a unique constellation of physical, economic, and social barriers. In fact, I'm proud to say that her decision repeatedly references the work of the brilliant women who formed the case committee for this intervention, including articles written by Jonette Watson-Hamilton and Jennifer Koshan at the University of Calgary, articles by Elizabeth Shilton, and also by Claire Young. She also references articles written by past LEAF board members, LEAF founding mothers, past LEAF legal directors, legal counsel, and countless others who've served on LEAF case committees in recent years. This judgment helps affirm the importance of both feminist scholarship in general, but LEAF's work in particular. It's a compelling testament to the many amazing advocates across this country who contribute to LEAF, including so many of you here today. I've now taken way too much time because I think this is such an important decision and a really impressive victory that I wanted to share with you today. I was going to talk about a case called the Queen and Slatter that is going to be argued on November 6th at the Supreme Court of Canada, but I'll skip over that and encourage you to go to our website to read more about it. And I also just briefly want to mention, because I really don't have time to cover law reform, the next big project that is happening at LEAF, our Feminist Strategic Litigation Project. I think you may have heard about it last year if you attended the LEAF Edmonton breakfast when the project director, Kat Owens, spoke. This project is in its second year, and next week we will be holding a 3-day national symposium called Gender Justice Now. That symposium will bring together activists, frontline service providers, lawyers, and academics to discuss how we can use the law to advance gender justice in Canada. I'm hoping that at least some of you are registered to attend the full symposium, but if you're not, please make sure to tune in to the 3 panel discussions that are going to be publicly broadcast and available to all. You can find information about that through our social media as well as on our website. So thank you so much for including me today. I obviously can only give you the smallest snapshot of the work we have been doing, but I really want to thank all of you for your support, without whom this work would not be possible. Thanks so much.
I'm sorry, we're having some technical difficulties, and Marcia Tate, who was going to present LEAF Edmonton's recognition award, is having some connection problems. So what I have decided to do is to move ahead in the program. We will therefore be presenting the LEAF Recognition Award after the keynote and the question period this morning. It's a real pleasure for me this morning to introduce my friend Val Napoleon. Val is the Law Foundation Professor of Aboriginal Justice and Governance at the Faculty of Law, University of Victoria. Val is from Treaty 8 territory in Northeast British Columbia. She's a member of the Saulteaux First Nation. She's also a member of the Gitxsan House of Luxon, Ganada Frog Clan. Prior to joining the Faculty of Law at the University of Victoria, Val was an associate professor who was cross-appointed between the Faculties of Law and Native Studies at the University of Alberta. She was also an adjunct professor in my department, and we were so very sad to lose her in 2012. Before attending law school, something that she likes to say that she did as a grandmother, Val worked as a community activist and a consultant in Northwestern BC for over 25 years. She played a really important role in the Delgamuukw decision. Her dissertation on Gitxsan law and legal theory was awarded UVic's Governor General's Gold Medal for Best Dissertation in 2009. Val's research focuses on Indigenous legal traditions, Indigenous legal theory, Indigenous feminism, citizenship, self-determination, and governance, and she's published widely in these areas. Importantly, she was a leader in the establishment of Canada's very first GID program, which is the joint JD and Indigenous law degree that is offered at UVic. And she's one of the founders of the Indigenous Law Research Unit as well. From her time as an activist supporting barricades and engaging in direct action, to her radical self-identification as an Indigenous feminist, Val has shown herself to be a woman of great courage, integrity, and conviction. She is also an exceptionally creative feminist legal theorist and painter. Val's talk this morning is entitled Contested Legal Personalities, Indigenous Women. Just a reminder that the question and answer function at the bottom of your screen is open. You can use it at any time to write questions or comments for Val. And at the conclusion of the talk, one of Leaf Edmonton's amazing volunteers, Ann Thomas, will pose the questions to Val. So welcome, Val. We're so thrilled to have you this morning.
Good morning, everyone. I'm so thrilled that you've decided to share your morning with me, and I, along with everyone else here, of course. And I'm grateful to Edmonton Leaf for this invitation. So I'm hoping everybody can see the slide, excuse me, that I have up. I want to just briefly explain it as I get in, before I get into the talk. So what you have, you see a Kokum grandmother, Raven. She's wearing the pink kerchief and she has her notebook computer out. So she's an Indigenous feminist grandmother trickster, born of national and international feminist Indigenous consciousness, past and present. There are also two women, Giksan chiefs from former times, earlier in the century. And there are the 5 women who launched the person's case. So these are the characters, representations of the characters that are going to join us on this talk this morning. The Kokum Ravens are my paintings. I heard once that we listen better if we have something to look at. So it's in the spirit of listening, and thinking and all of that work that we do that I offer these paintings for you to have a look at. Right. There we go. So this talk is structured as a conversation. The host here, you can imagine somebody maybe like Oprah or Sheila Rogers, but a little bit more tricksterish. And that's Kokum Raven seated here beside me. And Kokum in Cree means grandmother. So Kokum Raven is going to be exploring Indigenous law, and she's considering the possibility of expanding her trickster career to include being a talk show host. So around the world, tricksters are the first law teachers. They employ many pedagogies. They can teach us with love and kindness. They can slap us upside the head when we're taking ourselves too seriously. They can employ and most often employ the pedagogy of discomfort in the teaching. So as a law teacher, this is Kokum Raven's starting place. A society's legal order and laws reflect how citizens understand themselves and their world, their place in the universe, others, including non-human life forms. Our cosmologies determine the kind of legal traditions we create because fundamentally, our laws reflect how we think of ourselves and others, and they form the basis for how we treat one another. So for the most part, we can take our legal worlds for granted, especially the world that is created by the state, in this case, the Canadian state. We can take it for granted even though we disagree with it. So law, the root of law, are concepts of life and death, among other things. So, Kokum Raven clears her throat. Welcome to the first show. let me introduce my guests. And given that I'm a trickster, my guests can be from the past or wherever. First, we have the spirit of the former Gyeoksgun, matriarch of the Gyeoksan House of Luhan of the Frog Clan. And we have the spirit of Henrietta Muir Edwards, the lead plaintiff in the person's case. Gyeoksgun and Henrietta, welcome. Today, I want to explore how your respective legal orders created your legal personalities. So let's think about this idea of a legal person. Some have argued that the law creates a second birth, that there is an actual birthing of a legal person. From this perspective, notions of freedom and dignity are created and exist through law. This is the legal birth. Others argue the opposite. From their perspective, law is constraining of the person. In other words, human beings experience the construction of the legal self as a constraint. But I don't find either of these arguments particularly interesting. What really matters is which legal order one is looking at and which legal self is imagined. As Gyeoksgun and Henrietta look on, they're wondering if perhaps Kokum Raven is getting carried away with herself. Unperturbed, Kokum Raven explains, I'm more interested in looking at how different legal orders create and construct legal personhood. And I want to do this specifically from the perspective of women. I'm interested in how law constructs Indigenous women at different moments in time and in different spaces. What are the consequences of these constructions? So you may be wondering who the Gyeoksan are. You may recall the title court action, the landmark title court action, Delgamuuk. The Gyeoksan were one of the plaintiff groups along with the Wet'suwet'en. This map shows their location in northwest British Columbia. And I show you this, and I'm going to talk specifically about the Gyeoksan when I talk about Indigenous law, because societal specificity is critical to avoiding what can be a shallow pan-indigeneity when we talk about people too generally. So Kokum Raven smiles and says, let me introduce you to this talk. First, Gyeoksgun is going to tell you a Gyeoksan narrative, part of an oral history. Oral histories form the memory commons of the Gyeoksan and other Indigenous peoples. They hold legal precedent for future recall. Second, I'm going to present one legal analysis of that oral history. And finally, Henrietta and I are going to discuss the construction of legal personhood with a focus on gender. Specifically, how Gyeoksan law constructs women in the past and in the present day. How colonialism reconstructed Indigenous women, and Gyeoksan women in particular, and how Indigenous women are constructed in Canadian law. Excuse me. Gyeoksgun begins. This narrative is called The Origin of Gittin Max. Gyeoksan means people of the river of mist. Salmon has always been the source of wealth for the Gyeoksan. Gittin Max means people who harvest salmon by torchlight, and the village was located on the banks of the Sian. A young woman, the daughter of a chief, became Ubin, pregnant. No one knew who the father was, including the young woman. Each night she climbed up to her sleeping loft and the ladder was taken away. No one could get to her and she could not get out. Yet each night a handsome young stranger went to her. Her father, the chief, was very angry to learn of the pregnancy, and the Gitxsan were afraid. The chief ordered the people to pack their belongings and load the canoes. They were going to abandon the young woman. The handsome young man had disappeared. The young woman wept as she watched the canoes disappear around the bend in the river. Her mother had left her food and given her hurried instructions on how to deliver her baby when the time came. No one knew she was going to have triplets. Her food supply ran out. She sat on the banks of the Sian, thinking she could easily slip into the water. Who would know? Who would care? It was at this time the babies decided to be born. She knew she had to eat to keep up her strength and feed her babies. She held her 3 tiny babies and wept. In Gitxsan society, in times of great distress, Unstits, the supernatural being, comes to earth to help. Unstits appeared before the weeping mother and instructed her to take strips of bark from the birch trees and to make torches, and then to place these torches along the riverbank. The light would attract the fish so she could spear them. The grateful young mother gave Unstits her earrings in payment, and the Unstits disappeared. Each night, the mother would bundle her babies together and leave them in the longhouse, and she would go to the river to fish. She became strong and confident, and soon she had many salmon hanging in her smokehouse. Her children grew very quickly and soon were a help to her. They hunted and trapped small animals, and they fished, they picked berries. The young mother told her children that her family and people had moved away because she did not know who their father was. She instructed her children and taught them about the land. Many years passed, and her father forgot his anger. He sent out his warriors to fetch the bones of his daughter so that he could mourn her. The warriors returned with astonishing news. The chief's daughter and his 3 grandchildren were alive and well. The chief and his people returned to Gitxsan to find a woman with much wealth in the smokehouse. A great feast was held to celebrate, and Gitxsan names were given to the children. Kokum Raven says, "Thank you, Gitxsan. Now we're going to take one way into this narrative. Please note there are many ways into the stories." Henrietta has been listening patiently. "Hey, Kokum Raven, what are you trying to do here? This doesn't really look like a legal case, and it doesn't sound good for women." Kokum Raven responds kindly, "It is not a rule book, but a way to think about problems, Henrietta. And Canadian law cases are stories too, just told in a particular way. And some narratives are counter stories. Let's think about this narrative in light of collective responsibilities to single mothers today and about the creation of vulnerabilities. This will be the animating themes for our analysis." So, one way into this, one way to learn the law from it. What's the problem? What's the issue that the story is concerned with? Here, with the themes that we have, one question is, what is the proper response when you're abandoned by your family for something you had little or no control over? And what is your proper response when you're entirely responsible for those that are vulnerable? We're going to skip over the facts given our time constraints here. If you were law students, you'd have to do all of that work in the JD program. So what's the decision? So how did people resolve the problem here? And here we have the young woman deciding to survive and to decide that her children would survive. There was also a supernatural being who responded to her distress and taught her how to fish with torches. And we also know that law doesn't interpret itself. When we talk about supernatural or otherwise, it's still human interpretations. What was the reason behind the decisions? So here we have some things that are said, that are explicit, and other things unsaid, implicit. So the father should not, unsaid, the father should not have left his daughter and unborn grandchildren to die. When the village moved back, the young woman was recognized as a survivor who triumphed. What was said was that the young woman asked for help in time of great distress. She not only asked help for herself, but for her children. And what do we have to bracket? What is it that we don't yet have the terms of reference for? And there are a number of things in this narrative. One is, what are the collective responsibilities today for single mothers? Another is, what's the role of the young woman's mother, given that this is a matrilineal society and she had specific legal responsibilities as well as familial responsibilities to her daughter? And what's going on when Unstits, the supernatural being, doesn't respond to great distress? And also, did she consent to have sex with the stranger that came to her? Giaxgun, Kokumaraven, you have to analyze a lot of stories, the same as you have to analyze a lot of Canadian law cases to understand one area of law. This one narrative gives us insight, but it's not a body of law. It's just a little taste of how we can substantively and procedurally articulate Giksan law by drawing on historic legal resources. Yes, Kokumaraven acknowledges. And then she asks, what is the Giksan imaginary? She turns to Henrietta. You don't have to provide this kind of background because your legal order and law and legal institutions are not invisible. Most people know that there are courts, law enforcement, legislation, lawyers, judges, but all of that is invisible for the Giksan legal order and for most Indigenous peoples. Now, according to Giksan law, only a Giksan person or legal personality has rights, protections, privileges, responsibilities, and legal liability. Kokumaraven is on a roll. Giaxgun is secretly wishing she still smoked. Taking a breath, Kokumaraven asks, so how might women and girls have understood themselves historically as legal persons in Giksan society in accordance with Giksan law? How about today? How do women and girls understand themselves as legal persons? Obviously, as with every other society, Giksan women and girls would understand themselves in relation to how Giksan society was organized and how the normative order actually operated in and through their lives. Kokumaraven turns to Giaxgun. And what do we know of Giksan law and legal order? Giaxgun begins to explain. First of all, Giksan society, as with many Indigenous societies, was and is non-state with decentralized structuring of its economic, political, social, and legal ordering and its institutions. Secondly, political and legal institutions operated through the matrilineal kinship units. These were called houses, extended families. And it's the house that is the land and fishing site owning entity. There was no higher boss, no legal authority that was higher than the house. In turn, the houses formed part of the clans, which operated as alliances with other Indigenous peoples. And since the houses and the society is matrilineal, every person is born into their mother's house. That's how the women and girls would understand their membership, through their mother. Keep going, Gex Gun, Raven, Kokum Raven prompts. So, in other words, their children and their sisters' children and all the children of all the other female house members would form and be responsible to the same kinship unit and its governance, would be part of collective ownership of the same territories, would be legally and politically defined by the same owned oral histories, be entitled to the same privileges and prerogatives, and be subject to house obligations and liabilities. Legal personhood for women and girls begins with this embodied construct, which is absolutely central to Gitxsan governance and strength and the health of its legal order and its economy. So legal agency is a fundamental legality within Gitxsan law, within Gitxsan society. Within the house, women and girls, who along with their brothers and male relatives comprise the house entity itself, its governance structure. House members are individual agents within the house, and beyond the house, it's the house that's the collective legal agent. Legal personhood means that women and girls understand themselves as individual agents and as part of collective agents. Historically, marriages were arranged, and I've written about same-sex marriages and sexuality elsewhere, so I won't take that up here. Kokum Raven looks at Henrietta, who is paying close attention. Henrietta, you go over this next bit, please. So historically, Gitxsan women maintained their own economic lives because their husbands would be in different houses with different territories. Women understood that their participation in the marriage was necessary to their house because of territory location, political alliances, trade relations, and conflict management. Women would also have been entitled to no-fault divorce and could publicly initiate and complete divorce proceedings with the support of her house. Land is essential to Gitxsan women and girls, and they would have had access to various house territories, their own, as well as by arrangement to other house territories. Around each woman, there's a complex network of kinship relationships with corresponding legal obligations. In turn, women and girls would have had obligations to others. Gex Gun pipes up. On leadership and governance, here is our amazing champion, Melanie Mark, Minister of Advanced Education. Some women in the Gitxsan system are able to increase their status and authority through obtaining chief's names, no small accomplishment for anybody. Gender is still contested in the past as it is today. Henrietta steps into the conversation. It's important not to idealize the past. Gitxsan law had to do the hard work of law in the past as it does today. All societies have to deal with human violence and vulnerabilities. That's universal. Gitxsan people were no more violent than anybody else. And historically, Gitxsan women experienced violence, including sexual violence, from Gitxsan and surrounding peoples. We see this violence recorded in the oral histories so we can learn from it. It's a public memory, a precedent archive of law. We can also learn legitimate legal responses and processes for dealing with that violence. Yeah, Kokum Raven begins to share. If women were kidnapped, they had a right to be redeemed unless they chose not to be. However, if women were seriously harmed, including by another Gitxsan citizen, they had a right to legal action and compensation that would be taken up by their mother's house and sometimes their father's house as well. Historically, women, as with others who were injured or wronged, had a right to equal negotiation with the offender. They weren't sidelined as victims in this process. What's critical here is that there is no designated separate group of legal professionals or centralized bureaucracy of law. Women were responsible for knowing and maintaining the Gitxsan legal order. In short, women were part of Gitxsan collectivities, and they had obligations and responsibilities back and forward to them. They would have had recourse in Gitxsan law for conflicts or injuries. And while it's true that women's status could vary depending on a number of factors, they also had a high degree of mobility and authority and autonomy within their society. Raven turns to Gitxsan. What about colonization? Gitxsan is shaking her head. Colonization has undermined Indigenous law and legal institutions. So Indigenous law has not gone anywhere, but it has to be rebuilt. Raven turns to Henrietta, who takes a deep breath and says, I've been watching our history since the Persons case. I know, for instance, that Indigenous women did not get to vote until some 30 years after white women. Gitxsan cuts Henrietta off, and we have very recently concluded the national inquiry into the missing and murdered Indigenous women and girls in Canada. You know that this was launched to investigate the actuality of over 4,000 disappearances and murders of Indigenous women and girls. The final report, over 1,200 pages, and it brings up the language, the controversial language of genocide. Thank you, Henrietta. So I take the position that the missing and murdered Indigenous women and girls in Canada and elsewhere in the world are legal agents, persons, citizens. They made the best decisions that they could within the world and the constraints and power relations that they were a part of and that which surround them. So what happens when we think of Indigenous women, when we think of them as ascribing meaning to their decisions and actions, and when we take their political circumstances into account? Over the years, I've asked students and audiences to imagine missing and murdered Indigenous women and girls in this way, as legal agents, as persons, as citizens operating within and through their surrounding power relations. I would then ask whether this switch in perspectives reshaped their understanding of the missing and murdered Indigenous women and girls. These are deliberate questions to disrupt the public imagination with its all too predictable pathologization, which render Indigenous women and girls into one-dimensional victims. Sometimes my questions make no difference at all because the assumptions about Indigenous women and girls are just too deeply entrenched and therefore unassailable. Kokum Raven continues. Gitxsan, would you please tell us what happened in this colonial erosion? And Gitxsan continues here. Well, Gitxsan women and girls experienced the establishment of small reserves, the prohibition of political activities through the imposition of the Federal Indian Act. The reserves were a tiny percentage of Gitxsan lands. They fractured the larger legal order through which their law operated. And despite all the Canadian prohibitions, Gitxsan people continued with their laws, with their land ownership responsibilities, but their ability to generate wealth from their territories and to maintain their economy was damaged. So what happened for women and others was they suffered a disconnection between the public fulfillment of their legal obligations as required by Gitxsan law and their ability to protect their land. So there was a shift from horizontal power relations within Gitxsan law to vertical power relations. And all of this still hampers Gitxsan law today. The colonial constraints haven't gone away, and it continues to undermine Gitxsan law. So Henrietta speaks up. This is depressingly familiar. Kokum Raven is nodding sagely, and she jumps in. Women and girls were not active legal agents in the Canadian laws that shaped their lives or experiences. Under Canadian law, they were not able to decide whether they could, where they could live, whether they could get a divorce, or to choose who to affiliate with. Women had no protection from Canadian law in the event of harms or injuries. Kokum Raven looks at Henrietta. And Henrietta smiles. You know, this is really, really different from my legal history. However, from my study of history, despite colonialism, Gitxsan women and girls still understand themselves as part of a lineage that has deep connections to certain lands. They continue the legal obligations wherever they can in their lives, and they still advocate for their system, in the system for their children. Kokum Raven is considering all of this. And so she says, what's happening today is that Gitxsan women, and same as other Indigenous women, are navigating more than one legal order in the same geographic space, and there are conflicts between these legal orders. Gitxsan women and girls are experiencing gendered and sexual violence in the past as in the present day. Some of the missing and murdered Indigenous women and girls are Gitxsan. Today, there's shameless and normalized sexism in Gitxsan and other Indigenous communities. And the violence against them is at the same appalling rate as there is elsewhere. This is about a lawlessness created by the undermining of Gitxsan law and other Indigenous law. It's also a failure of Canadian law to protect Indigenous women and girls. Raven turns to Gitxsan. Tell us more about the missing and murdered Indigenous women and girls inquiry. Well, the inquiry report looks at a number of issues, but part of what it does is it locates Indigenous women and girls within the Canadian legal framework. And for the most part, the calls to action are addressed to institutions outside Indigenous communities. It will be a valuable resource, but unfortunately, the rights that Indigenous women and girls have, including human rights and self-determination rights, are located outside Indigenous law and are not recognized as deriving from within Indigenous legal traditions. At the Indigenous Law Research Unit, we're researching and restating human rights from internal Indigenous legal perspectives within legal traditions, including gender rights. Raven turns to Henrietta. And how would you work with this? Well, you start by asking how within Indigenous law agency is constructed, how dignity is destruction, inclusion, and all of these constructs, how they are principles within different legal traditions and how they might be brought to bear on contemporary issues that are before us. We can draw on a series of questions, and these are part of the work of, we draw on Emily Snyder's work from Saskatchewan about looking at how gendered perspectives shape Gitxsan and other laws. And we start with the understanding that all law is gendered. And then we look at how the material consequences of those play out for Indigenous women. Kokum Raven turns to the others. I want to share a quote from Jean Taillé about a recent horrific case of violence against an Indigenous woman. This case epitomizes the consequences of erasing the humanity of Indigenous women. It's not an abstract, they're very real consequences for all of us. So this is Indigenous lawyer Jean Taillé, and she asks, is there justice for Indigenous women who've been sexually assaulted in Canada? The case about Cindy Gladue, a victim of sexual violence who bled to death in a hotel bathtub. The court found that while Bradley Barton had lied and destroyed evidence and admitted that he caused her death, he was acquitted at trial. The Alberta Court of Appeal overturned the acquittal and ordered a new trial for murder and manslaughter. The Supreme Court also ordered a new trial, but only for manslaughter. Miss Gladue was an Indigenous woman and a sex worker, and she paid for both of these facts with her privacy, her dignity, and her life. It was Miss Gladue's life and body that were on trial. She paid another new and shocking price for this trial. The court brought part of her preserved pelvic vaginal tissue into the courtroom as evidence of the wounds she suffered. She was literally made an object called a specimen and tissue. There were more than 50 references to her in the trial as Native and prostitute, and she was robbed of her humanity. Cindy Gladue was a legal agent and a person according to Métis and Cree law. She made the best decisions that she could within the constraints of the power relations that she was a part of. Gix Gunn jumps in. Don't forget Joyce Echequan. She was another example of the profound disregard of Indigenous women where our humanity is dismissed. We have to honor Joyce Echequan. Some of this work is about learning to see across different legal orders, learning to see that which is invisible, as this wonderful image illustrates, looking through, Gix Gunn and Henrietta have to do this work, looking across the different universes, legal universes and legal worlds that they're a part of. And Kokum Raven is jumping up and down. We're such a team, but we sound too much like law professors. And I wonder if there are questions since I'm past my time.
Thank you very much, Dr. Napoleon, for your inspiring, enriching, and very, very creative talk. It was wonderful to have the images as well to look at. I'm just seeing notes of applause coming in from all of our from the chat and the panelists. And the first question recalls that you mentioned that there were different houses and that a husband would have a house and a wife would have a house. How are the houses created or passed down through generations? And how would two houses in a marriage resolve conflict?
So the house groups are, it's a non-state society, as most Indigenous societies were. But they had systems of law, and so authorities, political and legal authorities, were distributed through other institutions which look differently than Canadian institutions. For the Giksan, a house, this is an English term based on the former longhouses, were a series of extended families that shared an oral history. And so you're born into your mother's house, and the way the society is structured is that you always marry outside of your clan. So all of the houses form 4 clans. And then your father will always be in a different clan. And there are legal obligations, economic obligations that are separate between the two, between your mother's side and your father's side. And one of the observations is that this might have been a way to prevent the male power blocks from forming. There were very effective ways of conflict management, and I've gone through looking at the historic records, for instance, and looking at how did people manage different conflicts. And the purpose of laws, as you know, is not to do away with the conflicts, but to find effective, reasoned, principled approaches for resolving them. And then when that failed, there was war. And so, Gixan law in its entirety enabled people to do that. Gixan law wasn't perfect, and it doesn't have to be. It enabled people to manage themselves as a society through time.
Thank you. In another question, in Gixan law, is agency the core element of legal personhood? And how can this work against the dehumanization of Indigenous women under Canadian law? It's an excellent question.
Yeah, thank you. I think, just imagine if Canadian society didn't have designated professionals who took care of law, like through law enforcement, legislation, all of the courts, all of the ways that the management of our legal worlds are taken care of. If that didn't exist and each one of us was responsible for the management of Canada, it means that we are more directly legal players in the law of our worlds, and within that, legal agency and dignity is an essential component. It's an essential element. It's a legality. It's what makes law law. So if we understand that from one legal perspective, how might we learn from that and look at how agency is a part of or not of Canadian law? Basically the other thing, the work that we're doing with gender and with human rights and so on, is looking at how Indigenous concepts of agency and so on, how might they be brought to issues like citizenship? How might they be brought to land management or child welfare or other things that are going on? And so it's not just individual agency; it's individual agency that's part of collective agency. And it's about citizenship. It's about rebuilding citizenship.
Thank you. I have another question from Leah Sismas, who notes that you are such a gift to all of us. I just want to reiterate that because it's a very, very common comment. Leah is interested to learn more about dispute resolution processes as well as disciplinary measures when those are required. And I'm assuming she means from the Gitxsan tradition.
Thank you. So I've written about Gitxsan dispute management, and I could provide copies of some of those papers, like about what are the steps. I mean, you can. It's amazing. You can look at things and you can say, okay, so here there was a neutral person in that system who was assigned. Here there was a neutral village that was assigned. So you can, and here are the different roles through that whole legal process, because law isn't just a list of rules, right? It's ways of thinking, it's legal processes, and that's where you find legitimacy. So the questions are always about, how do people understand legitimacy? What makes things legitimate? How did that work historically, and how might that work today? Because, in the past as today, we have to deal with abuses of power. We have to deal with all of those kinds of struggles, which are the messy parts of human beings living together.
Thank you. I think we have time for just one more quick question. Emily Gerbrandt thanks you for your inspired talk, and was wondering if you could speak further to navigating looking through conflict or direct contradiction between Gitxsan law and the Canadian legal order, particularly under Canadian legal imaginations still practicing the ongoing erasure and the attempted elimination of Indigenous women, presently performing violence against Indigenous women like Cindy and Joyce, as you so notably mentioned.
Yeah, thank you for that. The big challenge, my colleagues and I have said for a long time that Indigenous law hasn't gone anywhere. It's still a part of Canada. It's been undermined and there are distortions. The work of today is about rebuilding Indigenous legal orders so that it's a part of being a people. Law is a distinct mode of governance, and if we can get that, then we can understand why it's so important to rebuild it in its and then find ways to how to relate to Canada. But the thing is, like, it's about that rebuilding so that there's actually symmetrical relationships between Indigenous law and Canada, whether it's Gitxsan or other law. Right now, so much of Indigenous law is invisible, and people are learning and doing the work in every field to reclaim that, to rebuild that. And it's really, really hard work. So we have, I teach Gitxsan land and property law alongside property law. And my colleagues and I are doing that with other legal orders and subject areas. And the work of re-articulating substantively and procedurally Indigenous law is possible. We are doing it. We've been doing it for a lot of years, along with others like the Wakotewin Law and Governance Center that's at the U of A, and along with other peoples across Canada. So that's not a direct answer. I'm just, the work is possible, it's going on, and it's hard work.
Thank you very, very much for your inspiring talk, Dr. Napoleon. I think at this time we have to end the questions, and just reminding in the chat is your email address, and we'll be sending a link so the conversation does not end with the breakfast. Thank you so much.
Good morning. I want to apologize for earlier when I was about to present the Leaf Edmonton Recognition Award that my computer froze. I also want to mention that we will be going a little bit past 9 today because of the technical problems. My name's Marcia Tate, and I am chair of the Leaf Edmonton Recognition Award Committee. The award is given to individuals, groups, or organizations which have made a significant contribution to substantive equality of women and girls. Prior to announcing this year's recipient, I want to mention the recent passing of a previous recipient, Nellie Carlson, an activist who championed equal rights for First Nations, Métis, and Inuit women and girls. This year's award goes to Dr. Tracy Baer. Dr. Baer is assistant professor at the University of Alberta in the Faculty of Native Studies and the Department of Women and Gender Studies. She's been recognized for her work on various projects which nurture resilience within Indigenous communities, placing special value on the resilience of Indigenous women and girls. Her projects include the Walk to Bridges program with incarcerated women, providing educational opportunities through a joint class of University of Alberta students and incarcerated women at the Women's Institute. As lead researcher of the University of Alberta Indigenous Women and Youth Resilience Project, which responds to colonial and patriarchal systems of violence by highlighting resilience. As a member of the national collective that supports Walking with Our Sisters, an art installation dedicated to remembering and honoring thousands of missing and murdered Indigenous women, and also through developing and presenting the massive open online course Indigenous Canada, which introduces viewers to important, diverse topics. And on behalf of Leaf Edmonton, I'm pleased to present the recognition award to Dr. Bear. Dr. Bear.
Hi for that. Thank you so much. Danse Tracy Bear Netsigason, Egwa Montreal Lake Cree Nation, Otsenia. I'm from Montreal Lake Cree Nation, which is northern Saskatchewan and nowhere near Montreal. I really want to say thank you to Dr. Napoleon for the brilliance, not only in her paintings, but the storied account of Gitxsan law through these amazing paintings and your incredible mind. Dr. Napoleon is such a inspiration to me and many of my colleagues still here at the U of A. She's been a mentor to many of us. I also want to thank my nominator, Dr. Michelle Mayer, who's the chair of Women's and Gender Studies, and also the awards committee. It's such an honor to be nominated for this award and then to be given this award today. A little bit about myself, and I think why Michelle wanted to nominate me is I work with a team, and we all know that having a happy and fulfilling intersection of life and work is really hard to come by. And we've all heard the saying, right? If you love your work, you'll never work a day in your life. And I always thought that type of adage was reserved for high school guidance counselors or maybe those daily calendars that are inspirational quote type of things. But the truth is, I really do love my work. And another truth of the matter is the type of work that I'm privileged to do is never, ever accomplished alone. There's not one milestone that I've ever achieved alone. It's my happy, healthy, amazing children, my PhD, a black belt, my spiritual endeavors, my academic achievements and awards. These are all done with hand-holding, encouraging text and weird emojis, late night Chinese food, long dog walks, kayaking sessions. And so I'm really blessed to have a tremendous amount of support in all the work that I do. And the work that we do at the Edmonton Institution for Women, which is a federal prison. We also work with Buffalo Stage Wellness House, and which is a transition house for incarcerated and formerly incarcerated women. So we have 3 tiers of working with Indigenous women who are incarcerated. And the first is to introduce a post-secondary course within the walls of a federal prison, which is the Walls to Bridges. And we bring 15 students from the U of A and 15 students from inside EIFW. And so 30 of them, we have a class inside the federal prison. And that's a 3-credit course for everyone. So we have achieved funding for that for the next 3 years for tuition and various things like that. The second stage of that is working with Buffalo Sage Transition House, where we invite 10 women from there to come onto campus and take one of my courses, a 3-credit course. And we have tutors for them and mentors as well. And the tuition is covered by our grant. The third stage of this is when we have found that many women who transition from the federal prison to the transition house, they want to come to university because they've got a little taste of what it's like. And so we have a mentoring place for them for when they come on campus. So in the 3 years that me and my team have been doing this, we have been able to have 3 women who were incarcerated at EIFW, and now they are full-time students at the U of A. Not to say that post-secondary education is for everybody. What my program does is offers an opportunity to have a taste of what post-secondary education can be for them. So this work means the world to me. This award means so much. And I want to say that I'm deeply, deeply grateful to all the people who work beside me, because I know that you see the significance in this work too. Thanks for doing this work with me, for we all are making a difference in people's lives. I'm very grateful, so thank you.
Thank you, Tracy, and thank you for your inspiring work, and thank you to Val for such an amazing talk. This has been a wonderful way to start the week and to think about this project of gender equality, and to focus in particular on the rights of Indigenous women and girls. We are ending the program. Actually, we're ending on time. I won't keep you, but I wanted to say before you go, thank you to everyone who came this morning. Thank you in particular to our sponsors, to our table sponsors, to the Person's Day Breakfast Committee. This is a huge amount of work to organize, and I particularly want to thank the committee, especially Jennifer Tomaszewski and Joanne Combs. I want to thank the Leaf Recognition Award Committee. I want to thank Juliana Barberas, who has provided us with such able tech support to enable our virtual Person's Day breakfast. And again, Leaf Edmonton and Leaf National are doing really, really important work. And we need your support in order to be able to continue on this project, which I just want to emphasize for women in Alberta is a crucially important project at this moment. So please go to the Leaf website. It's leaf.ca. You can become a member of Leaf. You can make a donation. You can become a monthly donor. And in this way, in those ways, you will help Leaf to continue with its important work. So thank you all for coming, and thank you all for making this very first virtual Leaf Edmonton Person's Day breakfast a resounding success. Thank you and have a great day.